And there we are without any hitch, glitch, or anything this time. We went on to LinkedIn Live straight away. Hello and welcome to everyone to our live on LinkedIn Networking for Women in Business. Connect, share, and grow. My name is Sigrid de Cast. I'm a book writing, publishing, and marketing specialist with focus on women in business to tell their story, share their expertise, make that global impact with their message in the form of a book. And it is really great to see you ladies here, and of course also to welcome everyone on LinkedIn Live directly. I see there are some people viewing from the outside, what I call the outside. We are on the inside. We are in the Zoom. So let me just give you a very brief understanding of what we are doing with this networking event. In a moment, I'm going to ask the ladies here in the Zoom room to give us their 60-second or thereabouts introduction to who they are, what they do, and what they have to offer for you. If you ladies have something that you want to announce, an event coming up, you have maybe a book or an offer, please say so in that introduction as well, which is fine. Everybody on the outside watching us on LinkedIn Live or even later in the replay, you are encouraged, invited, in fact, to put your introduction into the comments. Just put a comment in there about who you are, what you do, and what you have to share today. We will make sure that the post is seen all through LinkedIn for more than just today. So next, we will have a fantastic presentation today by our lawyer, our trademarking lawyer, Aparna Watal. She is all ready to go with an in-depth explanation of why, as entrepreneurs, we need to think about trademarking. That presentation takes around about 10 minutes or so. It might take a bit longer. You are encouraged to ask questions on the outside via a comment, and I will see that I catch that question from you and we will answer it. If there aren't any questions or too many questions, once that official formal part of our networking event has been completed, we will retreat into our Zoom room and continue with question and answers and meeting with each other and connecting with each other on a more informal level, really. So that is the explanation of what this networking live on LinkedIn is all about. And I think it is time now, ladies, to be ready. And I'm just going to call you as I see you on my screen to give us your introduction. Aparna, I will call on you as well on a brief introduction, please. And you're the first one on my screen. Would you take us away, please?
Oh, thanks, Sigrid. So glad to be here and to meet all the lovely ladies on this session and also on the people on the outside. Hello. My name's Aparna Watal. I'll give you a more detailed introduction about who I am and what I do. I've been part of Sigrid's network for the last few months, and I strongly encourage everybody who's listening on the outside to join this network. It has been so empowering for me personally to meet these women, other women who are, doing excellent things, operating their own businesses, taking charge and helping other women. I have learned a lot in the course of the last few months, and I'd encourage all others to join in as suited. So, yeah.
Thank you, Aparna. That's wonderful. And then I've got Agnes next on the screen to give us your introduction. Who are you, Agnes? What are you doing? Share, please.
Thank you, Sigrid. My name is Anja Zonrein, and I am known as the Queen of Reinvention. I am a women's empowerment mentor, but I help more specifically women who are over 50, so that can be 60, that can be 70. I help them create the freedom of time, money, and choice, important choice, that they crave while infusing the next season of their lives with purpose, passion, and impact. And I want to shatter the expectations of society, patriarchy, of what the life of a woman 50 plus should look like.
Fantastic. And sorry, I didn't mean to interrupt you there. There's many of us, and at that stage, looking for something new, different, ongoing. Thanks, Agnes. Lita, it is your turn. Please share. And yeah, there you go. Lovely.
Hey, hello. My name is Lita, and I'm from Latvia, and it's my first time on this meeting, and I'm very excited. And what do? I help women to connect with their souls, with their true being, and to live fulfilled, happy life, to feel confident, to understand that you can really make your dreams come true and you're worthy of going for your dreams. And my instruments is breathing, handpan, music, and also I write fairy tales for women, healing stories, healing tales to heal childhood trauma, to release this trauma, to understand how healing with divine energy happens. And all fairy tales are followed with some meditations, music, and coaching instruments. So yes, this is what I do. And my practice is located mostly in Latvia, but I work online, so I'm very excited to do something in English as well, to expand my practice.
Isn't that
So yes, thank you
wonderful?
very much for this
Yes.
here.
You are very welcome. It's really wonderful to be in the world and connect with the world. I mean, we all have our own little gifts, and you talked about digging into those deeper areas, levels of ourselves with what you do, Lita, which Agnes does to some extent, and of course, Aparna does it for us more or less on the outside of it. They all go together, those levels, and it is so important to share that because we each take an approach from a slightly different angle with a different view coming from different cultures, and that melting together, that interweaving of everything is just so fantastic and full of opportunities. Thank you, ladies, for your introductions. Now, we do have quite a few viewers on the outside, which is wonderful to know. I'm not seeing any comments here at this point in time. I hope it's not too slow at the showing it to me from LinkedIn. So that's all good. What we're going to do is we are going into our presentation, and I'm calling on Brand Protection Mastery, why trademarking is crucial for every entrepreneur. Welcome, Aparna. Again.
Thank you, Sigrid. I do have a presentation, just some slides, because a picture is worth 1,000 words. So I'm just going to share that.
I love that. I was just going to say trademarking is definitely a topic that we really all want to know about, but often we're not really aware of the full details. So yes, lovely. Thanks for that presentation with your slides, and go ahead, please take us away.
Just before I dive into the topic, though, I'd like to honor a modern day Australian tradition of acknowledging the traditional custodians of the lands we're all connecting from today. So for me, that's the Gadigal people of the Eora Nation, and I'd like to pay my respects to their elders past and present. Now, I kept my introduction at the start really brief, so I'll take the liberty now to talk about me, because you must be wondering, who is she and why is she talking about trademarks? Well, my name is Aparna Watal. I'm a lawyer and a trademark attorney practicing across Australia and New Zealand. Before becoming a lawyer, I was a chemical engineer, but that's a story for another day. I'm a partner at Halfords IP, which is one of the leading IP specialist firms in Australia and New Zealand. I manage the trademarks practice at Halfords, and our clients range from large multinational corporations to startups, scale-ups, and sole traders. And we absolutely love the range of clients that we have. And what really sets us apart is our client-focused and commercial approach. So we love working with all people from all walks of life at all stages of their businesses. Now, with that, let's jump into what exactly are trademarks and why should you care? So I'd like you all to take a moment, and if you run a business or if you have clients who run businesses, think about the products or services that you're dealing in or your clients are dealing in. If your client's a toy manufacturer, you may think, well, we're dealing in toys. Or if you yourself, like some of the ladies on the chat today, if you are offering services, counseling services, life coaching services, you may think, well, that's my service. I beg to differ. Because today, no matter what business you're in, no matter what product or service on the face of which you may think you may be providing, make no mistake, we're not just in a product or a service economy. You are squarely in the middle of an IP economy, and brands are at the heart of it. From personal brands, because as a sole trader, when you're offering your goods and services, a consumer is actually looking at who do you stand for? What do you stand for? And it's your personal brand that they're investing in, to large corporations like the Apples and the Microsofts of the world. And by the way, Apple's brand value this year soared to over $1 trillion because it's really the brands that people are investing in. And to really make that point and take that point home, I'll share this next slide, which shows that back in the 70s, the S&P 500, the top 500 companies, whilst only less than 20% of their stock market value was coming from intangible assets, today in 2020s, nearly 90% of their market value is coming from intangible assets, a good part of which is actually their brand value, the brand equity that they have built. So brands are crucial to your business's success. And that's where trademarks come in, because trademarks are the legal right that protects your identity. It is the registered right granted by the government, which gives you a defined monopoly in your brand, in your mark. Now, it is true that in many countries you can get rights in a trademark without actually registering it, but you need to be very mindful of the laws in the country you're trying to get that trademark, because several countries you only get rights upon registration. Even if you're in a country which allows you to have a trademark simply with use instead of actually having to register it, it is far easier to enforce your rights if you actually have a registered trademark right, as opposed to having an unregistered trademark right. You will still have a monopoly if you have an unregistered trademark right, but when you go to enforce that unregistered trademark right against a copycat or against an infringer, you're going to have to provide enormous evidence of your reputation in the brand, instead of just being able to show them, this is my certificate of registration for the trademark. I own the exclusive monopoly in this mark and you can't be using it. Makes your life far easier to really, protect the territory, protect the brand that you are developing and investing so much of your time and money in. And the other advantage of actually having a registration is, once your right is registered, it is on the trademarks register. Others who are looking to adopt a new brand will know that actually this mark is already taken by somebody else. So it deters others from adopting the same or a similar mark. So a registration gives you far better protection and better rights than an unregistered trademarks would. Okay. Now, I'll jump into 5 tips that I have for you to start trademarking like a pro. I'm sure several of you already are familiar with the process of trademarks, but there are certain factors, certain considerations that you should think about when filing an application, when looking to protect your trademark. And one of the key ones is avoiding descriptive or generic marks. Now, there is an inherent tension between marketing principles and trademark law. Marketing principles would like you to have a brand name, have a trademark that talks something about the product or service you're providing, that says something to the consumer. What is it that they're actually buying? But the moment you do that, you start leaning towards the red and the orange spectrum of this distinctiveness spectrum, which makes it harder for you to get your trademark registered. Because typically, most trademarks offices would raise an objection saying, well, the mark is describing the goods and services, so no one person should be allowed a monopoly in it. Or the mark is too generic, like number 1 or gold or super. that no person should really be allowed an exclusive monopoly in those words. Those words should remain open to other traders to use. So to the extent possible, and contrary to what marketing folk might like you to do or might tell you, err on the side of the green side of the distinctiveness spectrum. Adopt a mark that, if anything, is merely suggestive. It doesn't clearly describe what the goods and services are. It would be even better if your mark was arbitrary. For instance, Apple in relation to consumer electronic products. Apple is not using the mark for trading apples itself. It's completely, the choice of that name is completely arbitrary in relation to consumer electronics. Or something completely invented, something fanciful, like Google or Kodak. Some of the best brands in the world, in fact, have been that were completely invented novel marks that then acquired a reputation as a result of that novelty too, in great measure. So first tip, avoid yourself the pain of registering and then having to enforce a descriptive or a non-distinctive or a generic mark. Find a mark that is invented, suggestive, or completely arbitrary in relation to your goods and services. Then, moving on to the second tip that I have, which is written there loud and clear, do your searches. And I'll tell you why with a story. You can see a mark on your screens. It's iOS. And if I asked you who owns this trademark, I bet a lot of you would say Apple. Well, yeah, duh. Actually, it doesn't. iOS is owned by Cisco Technology, and Apple has to license that trademark from Cisco. And this goes to show that even big brands like Apple will often not be able to register their own marks. So it's important to, before you adopt a mark, before you put your heart and soul and money into a brand that you begin to love so much that you can't walk away from, do your searches. Make sure that the mark you're so liking and wanting to use is actually available for you to use and register. Halfords IP, we provide a free trademark search facility for Australia and New Zealand. So please look up our website. I'll drop in a link shortly, but do use search facilities that are out there that may be able to help you determine if the mark you are so committed to, so invested in, is actually even available for you to use and register. Don't fall in the trap of Apple that Apple did. And then third point, once you find a mark that is available, that's all clear, there's nobody else on the register or in the marketplace that's using the same or something similar to it, act fast and don't let anybody else beat you to the punch. File your application, get the application process rolling as soon as possible, and get your mark registered. I see so many times that people, when they adopted a mark, they did the searches, they found nobody else was using it, and that was great. They began using it, only to realize that in the meantime, while they were using it, thinking they were okay to use, somebody else has gone and registered it on the register. You'd end up having to fight for the registration, disputing that registration. So to avoid yourself that heartache, that cost, register your mark as soon as you find it's available for your use and registration. Now, the fourth point is when you're spending so much money in filing for a trademark and getting it registered, you don't want to have to keep going back to the office to get another registration every time your brand pivots a little bit or your goods and services pivot a little bit. So the better strategy is to file an application to start with quite broadly that would cover you for some variations in your mark, for instance, variations in color or variations in font and stylization. And that would also give you some flexibility to grow your product range or service range organically in the future. So looking at that first point, when you're looking to file an application, if you've let's take the example that's on the screen, right? So let's say you've come up with a beautiful ice cream flavor, which is just gorgeous. Let's say lavender flavor of ice cream, like a different variation of it. And you're calling the product Penny Lick Ice Cream. You have come up with the beautiful logo that's labeled number 1 on the screen, the Penny Lick Ice Cream Company. Now, if you filed and registered Penny Lick Ice Cream Code, the logo in number 1, and another entity started to use the logo in number 3, they would probably argue that, well, yes, Penny Lick is common to the two marks, but our logo is completely different to yours. So you would be in a far better place, a far stronger place of taking action against entities such as the one that are using the logo in 3 if you had registered the plain word mark Penny Lick by itself. In that case, if somebody was to use the plural of that word or depicted those words in any stylization or completely different font and color to what you were using your brand in, you would still have a claim of infringement against them because they've still used the words Penny Lick in their mark. So when filing to register a trademark, you'd get broadest protection by registering it in the plain word mark format. Now, the second point I mentioned there was in relation to goods and services, because very, very often I see that startups have started with an audience in mind, with a product in mind, but as the business grows, the product evolves, and sometimes businesses have to pivot in a tangentially related direction. And you'd be far better off by actually covering yourself for that protection in the first instance rather than having to keep going back to the office to get a new registration. So when filing for a trademark application, no doubt you should be getting protection for the core goods and services you want protection in. But also have a think about what are the tangentially related, the closely related goods and services that your business could eventually organically grow into providing. That's what I call the aura of protection that you want around your mark. So there's the core protection that you want for your goods and services, but also the aura of protection. For instance, going back to that ice cream example, surely you'd be filing in Class 30, which covers ice cream goods. But contemplate, do you tomorrow foresee selling that special lavender flavored jelly product in the future? And if you do, contemplate covering jellies at the start when you're filing the application rather than having to go back. And in the meantime, potentially somebody else has gotten on the register for those products. So avoid that by filing broadly at the start. And the second point under goods and services is related. Have a 3 to 4 year plan. In Australia, you get a 3-year window to commence use of your registered mark. So have a think about what your product, what your business might look to do in terms of growth in the next 3 to 4 years, and cover that in your application. Now, the last point, the very important tip that I'll part with is be careful who you're filing the application in the name of. So the application should be filed in the name of the owner of the mark. And according to law in Australia, an owner is the person who authors the trademark and is the first to use or has the intention to use or intends to assign it to an entity that is yet to be formed. So many times I see a sole trader, let's take an example of a sole trader, for instance, a psychologist who's offering counseling services. They came up with the brand name, they started to use it as a sole trader, as themselves when they were offering the counseling services. They then incorporated a business, a company, and when it came to eventually filing the trademark application, they ended up filing the application in the name of that entity. But who was the first to use that trademark? It was actually that sole trader who was using the mark when that company had not been incorporated. So technically, the application should have been filed in the name of the individual, the psychologist who was offering those services as the sole trader. Or it could even be a reverse situation where, you've got a company that is offering the services, and it's a company with one director, one shareholder, and the application, the director files in their own name thinking, well, I want control over the trademark rights, I want control over the intellectual property. Whereas the company, the entity, which has a separate legal entity and identity, was the person that was using the trademark. So the trademark application in that case should have been filed in the name of the company, not the director of the company. So if you have any questions or any doubts as to who should be the applicant of my trademark application, contact a trademark attorney, contact a solicitor, an expert in the field who can help you, who can guide you, knowing the history of how the trademark was adopted and can tell you who would be the best applicant for the registration. There have been numerous cases where well-established registered trademarks that had been on the register for many years, and when somebody tried to enforce them against an infringer, those registrations were challenged and they came undone on the basis that, well, actually, they were filed in the name of the wrong entity, so that registration should not have been granted in the first place. So be careful when you're filing an application. So that was my fifth and last tip, and happy to take any questions.
Absolutely excellent, Aparna. And there's a lot of interest in this from just right across entrepreneurs, sole traders, as you mentioned, coaches and consultants who often are sole traders or the name of their business, the head of the director of their company. And of course, things are very different across the world as well, aren't they? There are different rules and regulations. So it really is not that easy to find out yourself and make sure you know contact somebody who knows. Agnes, you'd like to ask a question? Please go ahead.
Yes, that's exactly about the worldwide protection. So my name, the Reinvention Mentor, is protected, but the business is a legal entity in the UK. So I have registered it in the UK, but I work worldwide. How do you go about protecting a brand worldwide?
It's an excellent question, and one I didn't get into because it's a whole different can of worms to get into, but I'm very happy to talk through some salient points that you ought to know when you're looking to protect internationally. Now, the first thing to know is that trademarks are territorial rights. Pretty much all registered IP rights are territorial. You get the right in the country where you've got the registration. So you can enforce it in that country. So you've got the UK registration. To get international protection, you would have to file an application, either a national application in each country, which basically means going into, filing a local national application in each country of interest, or there is an easier mechanism to do that. There's something called an international application where there's a Madrid Protocol. Countries that have signed up to the Madrid Protocol, in those countries, you file an international application and you can designate those countries under your international application. So it becomes like a tick box exercise. You are essentially filing the international application with the World Intellectual Property Organization. They have an international bureau there. You file the application with them, ticking the boxes of the countries that are parties to the Madrid Protocol and that you're interested in getting protection in. You have to pay the fees there with WIPO, which sets out what the government fees for the countries would be, what the WIPO fees will be. And then what WIPO does, they will review your international application for any formalities issues. So a very basic check around the goods and services, the applicant. If you have met the requirements you need to meet to be able to file an international application, which is that you need to have a registration or an application in your home country, which you do, so you can file the international application. They'll do that formalities check. And if everything adds up, they will then forward your designation, the application, to each of the countries that you have designated. For instance, if you've designated Australia and New Zealand, the Australian Trademarks Office and the IP Office in New Zealand, they will receive the international registration designating their countries. And then those local offices will examine your application, similar to they would examine a national application and assess it for the local register issues or issues with descriptiveness based on the local laws. So an international application going through that Madrid Protocol route provides a far more convenient and also a cost-effective method for getting international protection. Whilst I've said that it's cost effective, if you're only filing an international application, let's say you only want protection in one or two overseas countries, I would say do a cost comparison, because in some cases, if the local fees in those countries is not much, you may be better off doing national applications in those countries as opposed to an international application, because then you're also paying YPOS fees. So an international application makes most sense and is cost effective when you're getting protection in many jurisdictions. One or two jurisdictions, you may be better off just going the national application route I mentioned first.
That makes sense. Super. Thank you so much. And this was a great presentation. And I'm happy to see that I've done everything the way I should.
Thank you. That is absolutely excellent. Aparna, as I said before, there's a lot to it. And I just from my perspective in general, there is always more to something than on first approach, on first view. So the same as when people come and want to write a book, or they already go ahead and have written a book and then come to me for questions. Ask your questions first, dig into things and find out all the layers, all the components that go into it. Excellent. And as I said, there's a lot of interest in this question, and so I will keep it open a little bit longer. I've got a question here. Somebody's asking, I'm a therapist. I did register a name. It sounds like it would be worthwhile to register it. I did register. So she might be asking, registering the business rather than she's just.
Yes, actually, that leads to a really important point, something that I didn't touch upon in the presentation, because I wanted to get into the tips really that you end up paying trademark attorneys a lot of money for. So I wanted to get as much of that free information out there. But a very important distinction to be drawn is business name registrations or company name registrations are completely different to trademark registrations, as are domain name registrations. Domain name registrations and a business name or a company name registration does not give you any property rights in that name. What gives you property rights is a trademark registration. In fact, trademark registrations and patent rights and design rights, all of these are intellectual property that many financial institutions are now accepting as collateral for business loans. So that won't happen with a business name registration or a domain name registration. So just because you have or if you do checks of the business names registry and the domain names, just because a trademark seems to be available in the domain name space or is available for business name registration does not necessarily mean that it's also available as a trademark for you to use and register. You must also do register searches of the trademarks register.
All I can say is complicated, everybody.
No, I know. And the unfortunate thing is in most countries that I'm aware of, the three systems, the domain name system, the business registration and company name registration system, and the trademark registration system, they don't really talk to each other. So you have to go three separate entities to get to the domain names registrar, to the company that manages the business name register, and then the IP registry of your country to get those separate rights. But of those three separate rights, trademarks are the only, it's an actual right in the sense, the legal right that you get. It's a property that you own, much like your car, but it's intangible. That's the difference.
I think the biggest point here is probably to get in touch with Aparna for a few questions at least. She can point you in the right direction, whether she is going to, take it further with you or you want to take it further with her. You can work that out. But I think get in touch and ask a few more personalized, customized questions to get the right directive there. It's certainly, you've given us a lot of things to think about, to reconsider, to look back at what I have actually trademarked. I want to just put one question in there, which does come up every so often, and which is something that I do see visually a lot out there online, that I think people are not aware of, which is the right way to do that. I often see people with their business name or some program name, and they just put the TM after that. And some people actually believe that that means it's registered, even though they haven't done anything about registering it. And they don't understand what that means compared to the actual R in the circle. If you just give us a brief explanation of that, if you don't mind, that would be probably very useful to a lot of people as well.
Yes, sure thing. So the superscript TM symbol can be used by anyone that is claiming trademark rights in the name they're using it against. So, for instance, I'll use Agnes, you as an example. You've got, you know, the reinventing queen. You've got that name. If you start using TM symbol next to it, you can rely on that as proof that, firstly, you know, you're claiming trademark rights in it. It also acts as a notification to others that, hey, Agnes is claiming trademark rights. It's her trademark. It's not a registered trademark though. So I talked in the presentation about unregistered and registered trademarks. Anybody can use the TM symbol because you don't have to have a trademark registration, but the R in the circle symbol can only be used in respect of a registered trademark in Australia and New Zealand. And in fact, it is an offense to use the R in a circle symbol against a trademark that is not registered. So be very mindful. If you have filed an application, it is pending, under examination, is yet to be registered, you can use the TM symbol, but you can't use the R in the circle symbol until you get that certificate of registration in hand.
Excellent. That's a great explanation, making it very clear for people out there that might have used the TM and not really understanding what they are doing there, what they mean by that. Thank you so much. It's been absolutely fantastic having those explanations, having that whole presentation for you. This replay, of course, will be available to everyone on LinkedIn once we are finishing off here now. This group, and just so that everybody on LinkedIn who is watching, listening in right now, and even later in the replay knows, this networking event runs on 2 levels each time. When we hold this, we have the outside on LinkedIn live level where everybody can watch and comment, put your questions out there, and we will answer them to the best of the ability of each speaker, which is always an expert who will be able to, or at least point you into the direction. And once the presentation and a few questions have been completed, we retreat into the Zoom room where we can, away from the open live eyes, continue our discussions with more personalized, detailed questions and other networking to connect. So that is what we are at now. There was that one question. I see still quite a few eyes out there, but we are going to say goodbye to LinkedIn Live and we are retreating into the Zoom room. I open up the invitation to everybody out there that you can be in the Zoom room with us at the next networking in about a month's time. So simply contact me and ask about it. And for now, again, thank you, Aparna, for that excellent presentation and the 60-second introductions of our ladies in this room. We are going to close the live on LinkedIn now, and we're going to retreat into our Zoom room. Everybody who has a question or further questions directly to Aparna, feel free to connect with her on LinkedIn. Thank you, everyone, and we will see you hopefully next month.
Hey, everyone.